Hey everyone, Harry here to talk about Trump's giving up on trying to remove a big 14th Amendment Section 3 suit against him. Okay, by now I think people are aware of this formerly arcane, really it is arcane, provision of the 14th Amendment that says when someone has sworn an oath to the United States and then engaged in, facilitated an insurrection, they are no longer eligible to serve in the federal government, and all kinds of interesting focus on whether this applies to Trump. Scholarly stuff, including by two prominent conservative scholars, and pretty much every big newspaper has added its own 2 cents. I've talked about it before. It's still, I think, a bit of a constitutional puzzle. Yeah, he swore an oath. Yeah, he, I think, committed or facilitated insurrection. You don't need a criminal trial to tell you that. But exactly what you do need is and remains a puzzle, and the Supreme Court is going to have to answer that puzzle, and they may not answer it in a very satisfying way. They may basically say, well, we can't do it, and we don't know who does do it. But the immediate point is there has already started to be a lot of action here, and it begins at the level of state secretaries of state, the people responsible for putting candidates on the ballot. And you have different secretaries of state already fielding efforts to keep Trump off on this basis. Some will do it. Trump campaign will sue them, and in the well-worn American way, it'll work its way up to the Supreme Court. Okay, the biggest and most serious one to date has happened already. It's in Colorado, and the group called CREW, Committee for the Reform and Ethics in Washington, something like that, but a well-known player in the public space, brought this suit under the 14th Amendment and against the Colorado Secretary of State, and says to say, you must take Trump off the ballot. Here's why. He committed insurrection, and he swore an oath. And, you know, the evidence you would bring forward, there's strong evidence, and this is a little bit off point right now, but what do you have to have it beyond a reasonable doubt, clear and convincing? There's some really tricky unanswered questions here. But the main thing is, okay, I'm going to do a little U-turn here to another subject we know that was arcane just a few weeks ago: removal. So we're seeing this happen in Fulton County, where Mark Meadows, four others, and believe me, Donald Trump himself will move to take a case that's been brought in state court, as this one has, and just bring it into federal court. Doesn't change the law, doesn't change the basic action. If it happened in Fulton County, looks as if it won't, it would just be, a violation of Georgia state law, but tried in federal court. Somebody asked me over the weekend, does that mean that Trump could pardon himself? No, it doesn't mean that, because it would still be a state law case. All right, so back in Colorado, this CREW brings this action and get Trump off the ballot. And the Trump campaign says, I want to remove it to federal court. And lo and behold, they've just folded up their tent and said, never mind. Words we basically never hear from Trump litigants. But there's two reasons. It's an open and shut case. Still, there's probably a bigger backstory to why they didn't push for a few more weeks, as they usually do. And why they're allowing this to be teed up. But two things happen. So removal, think about it. You're bringing it into federal court. You still have to satisfy federal court standing requirements. And the thing about the case from CREW is, if this were brought in federal court, there wouldn't be standing because it wouldn't be ripe. Throwing around some legal jargon this morning, but what that means is basically federal courts have to have live controversies that have really been, the battle's been joined for all kinds of reasons. And here the argument would be, the battle hasn't quite been joined. It's getting there. We can see it. But until it's actually joined, the federal courts couldn't bring it. Why can you do it in state court? State court's just the requirement in federal court comes from the federal constitution, and some state courts permit their courts to hear controversies that are not quite as clean and evolved and adversarial, you could say, and Colorado is one of them. And so under the removal statute, which says when can you bring a case from state court to federal court, one thing you have to have is standing, as you would have in federal court. And the 1447, you don't have to worry about the numbers, says there will not be a quiz on this later. If at any time before final judgment it appears that the district court lacks jurisdiction, the case shall be remanded. So, a command, no jurisdiction, goodbye, back to state court. And there's another provision as well that matters. In the state court criminal case, Trump, all six of them are saying we are federal officers and they are trying to hold us criminally. In that situation, you have an automatic right of of removal in the sense that you can bring it automatically, it doesn't matter what the state says, to federal court, and the federal court will decide, do you belong there? That's what happened with Mark Meadows. He brought it the first day, and the federal court judge just a couple of days ago said, you don't have a right. I'm now taking this case you've removed to federal court. I'm remanding it, sending it back to state court. Thus, by the way, our just published Talking Feds episode this week, remove, remand, repeat. All right, so that's for federal officers, and you can see why. If they're being subject to criminal charges, and basically it's just an attempt by the state to kind of meddle in federal sovereign function, they can automatically bring it to federal court. A federal court can decide because, a state, if you needed the consent of state parties, they would always say no. They're by hypothesis there to try to jerk you around and subject you to state court jurisdiction. But the provision that Donald Trump used, the only one he could use to remove, is a different one, a kind of general residual statute called just a couple provisions away from the one that everyone's used in Fulton County. And that's just for a plain vanilla kind of case with nothing special to it. For example, the presence of a federal official. And for that, it's pretty clear you have to have the consent of all the parties. If you're doing that and you're subject to that kind of lawsuit, you just have to, everyone's got to sign off on it before it can be removed. Otherwise, it would, there'd just be removal craziness in the courts. And here it's undisputed that the respondent, the person he sued, Gina Griswold, did not, the Colorado state official did not consent to removal. And that's just another reason. So 14th Amendment, Section 3, plus removal, hooray, go to the head of the class. And what happens here at the bottom line is is a little bit of a puzzle when you're looking at Donald Trump, which is he throws in the towel. He should have. He was dead to rights, but that doesn't always mean it for Donald Trump. So now this first and most important, perhaps, very kind of well-known litigants, powerhouse lawyers and the like will be tried not in Colorado federal court, but Colorado state court. And they will be arguing that Trump has to be off the ballot, and that if the Colorado state court agrees, that is on its way by fast track to the U.S. Supreme Court. Talk to you later. Thanks for tuning in. If you enjoyed this video and other Talking Feds content, please take a second to like and subscribe. Talk to you later.